Hi, everyone. My name is Baylee Butler. I'm a senior staff attorney with Southeastern Ohio Legal Services. As I mentioned, today we're going to be talking about kinship basics. I'm going to go over the different legal relationships a caregiver may have with the child in their care that you might see in school. So what rights do kinship caregivers have? It really depends on their legal relationship to the child in their care. You might hear somebody say they're an informal caregiver. What that really means is that there is no legal relationship established with that child. That means that maybe the child was just dropped off at the caregiver's house, or that the caregiver provides sometimes care for the child. But really, there's been no formal process either through children's services or through the court system or anywhere that gives any formal legal rights to the child. On the other end of that spectrum is adoption. Adoption, as I'm sure you're aware, is full taking of the parental rights. It severs the parental rights of the bio parents and creates a new parental relationship between the caregiver and the child. So that is done through a legal process. A formal adoption is granted by a judge. All those papers would be given to the caregiver so that they would have that. But the caregiver essentially stands in the shoes of the parent and should be treated exactly like the parent. In the middle are the next three. So the grandparent power of attorney is an affidavit that is signed by the parents of the child and only given to a grandparent. It cannot be given to any other caregiver or any other type of relationship that the caregiver might have with the child, an aunt, an uncle, a cousin, a friend, anybody. It has to be a grandparent. And what that does is it bio parent signs over a power of attorney with rights that allow the grandparent to enroll the child in school, participate in school events and school situations like special education and discipline. It allows the grandparent to stand in the shoes of the parent for specific situations. It also allows them to get medical care for the child. With the grandparent power of attorney, both entities, the grandparent with power of attorney and the bio parent, have the exact same rights. The bio parent can do exactly what they have always been able to do. It just gives some extra rights to the grandparent that is recognized by law. Next on their list is the kinship placement or temporary custody through Child Protective Services. What this is whenever a child has been taken into custody by Children's Services because of the bio parent or the custodian's abuse, neglect, or dependency. Children's Services has an obligation to make sure that they place that child in a stable home that tries not to disrupt them too much. So really the best option is for them to place them with a family member or a close friend who that child has a relationship with. The idea is that it will not disrupt them too much by placing them with a family member or somebody that they know and have a relationship with. That's always a best case scenario and the first thing that Children's Services should be looking to do when they take custody of a child. But in a kinship placement or in a temporary custody situation, the kinship caregiver is not part of the actual court case. It is the state of Ohio Children's Services versus the bio parent or the custodian that the child was removed from. So what happens is the state and Children's Services maintains legal custody of the child. They sign all the documents. They do everything. They're ultimately responsible for the child, but they place physical custody or where that child is living with the kinship caregiver. That still allows that kinship caregiver to kind of stand in the shoes of the parent, but it's on a temporary basis because in a temporary custody situation through kinship, the goal for Children's Services is always to reunite the bio parent with the child. That's not always the case. And sometimes what happens is the court will grant, after a period of time of trying to work with the bio parents, they will grant permanent custody to the kinship caregiver. And in that case, they are what's in the next category known as a legal custodian. And that is whenever somebody has legal documents stating that they have rights to the child. You can have two different types of legal custodians. Like I mentioned, you can have it through the Children's Services, but that's usually called a permanent custody situation. Or you can have a private custody situation, which is generally between two or more parties, where the parties are asking the court to decide who should have legal rights to make decisions for the child or the children. Once the court has made the determination the bio parents are unfit, the court will then make a determination based on what is in the best interest of the child or the children involved as to where they should go or who they should live with and who should be the legal custodian. Custody is meant to be a permanent and final arrangement. That is not always the case, but that is what the goal is in the law and for most. And to that end, that makes it very difficult to change. In order for somebody who wants to change custody, maybe the bio parent wants to try to get custody back of the child, they have to show that the circumstances have changed for the current custodian. such that the current custodian can no longer care for the child. It is not enough that something has changed for the bio parent or for the person who wants custody. So it's important to keep that in mind, that while they can't go back to court, they can't have another legal battle, it is difficult to have that changed. One quick note about the difference between emergency custody and temporary custody, because I hear this a lot. Emergency custody is generally seen most often with children's services cases. It is a situation where before anything has ever filed, you go into court without filing anything and just say, I need to talk to the judge. I need to let them know why this child is in immediate danger. And if you don't give me a right or an order that says I can have this child right now, that this child is going to suffer immediate harm. But emergency custody, the important thing is that it happens before anything is ever filed in court. For temporary custody, we see this a lot more frequently. Temporary custody is an order that a court makes that determines what happens while a longer custody arrangement is going on. So you file custody forms, and then you say, okay, well, we know that custody cases can take a long time. So in that meantime, that child doesn't need to be in limbo. We need to say, okay, where's that child going to live? Who has the right to make decisions for that child? And what happens now? It is not just a temporary order that says you can have the kids for 6 months and then we're going to dismiss everything. What it means is that you have a temporary order while the longer custody case is ongoing, and we expect that there's going to be a permanent order at the end of the case. If you have any questions, please reach out to me via email. If you have anybody who you think might be eligible for our services, low income, senior, need extra support, feel free to have them call our intake line or our SOLS phone number. And then we also have lots of resources available on our website for anybody who needs them. So thank you so much for listening and being a part of this, and good luck in the future.